Hello Year 12s and welcome to this video on the rights of an accused. There are 4 things that you need to do as you watch this video. First, take the very best Cornell notes that you can. Second, use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. The third thing that you need to do is have your vocabulary sheets open in front of you so that you can include in your vocabulary sheets the definitions of key terms or of any other words that you might not be familiar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. Once you've finished watching this video, please make sure that you read the pages from the textbook referred to on this slide. If you find any additional information from that reading that you think is useful, then make sure that you supplement your Cornell notes with that additional information. Let's get started then. On this slide, I've set out your learning intention for this video. Make sure that you write this learning intention down in your Cornell notes. As a result of watching and taking notes on this video, you should be able to explain the rights of an accused, including first, the right to be tried without unreasonable delay, second, the right to silence, and third, the right to trial by jury. What I'd like you to do now is to draw up a table in your summary books like the table on this slide. In the left-hand column, I've set out each of the 3 rights of an accused: the right to be tried without unreasonable delay, the right to silence, and the right to trial by jury. You need to complete this table by including in the middle column the source of each right, which may include the common law, the Victorian Charter of Human Rights and Responsibilities, the Victorian Evidence Act, the Victorian Jury Directions Act, the Australian Constitution, or the Victorian Criminal Procedure Act. And then you also need to complete the right-hand column of this table by including in that column a description of each right. You will be able to complete this table as you listen to the description of each right that accompanies the following slides. As you will learn, some of the rights of an accused that we're looking at are set out in a Victorian statute which is called the Victorian Charter of Human Rights and Responsibilities. In the slides that follow, I've abbreviated the Victorian Charter of Human Rights and Responsibilities to VCHRR. You can also use this abbreviation when you're writing an answer to a SAC or exam question. However, if you do use this abbreviation, make sure that you use the full title, Victorian Charter of Human Rights and Responsibilities, the first time, followed by VCHRR in brackets. In the rest of your answer, you can then refer to the Charter as the VCHRR. Let's now look at the first right of an accused as set out in our learning intention. Under the Victorian Charter of Human Rights and Responsibilities, an accused person has the right to be tried without unreasonable delay. You need to be able to both identify the source of this right and to describe this right. The source of this right is the Victorian Charter of Human Rights and Responsibilities. This right is actually contained in 2 sections of the Victorian Charter of Human Rights and Responsibilities, that is, in sections 21(5)(b) and 25(2)(c). Together, these sections provide that a person who has been arrested or charged for a criminal offence has the right to be brought to trial without unreasonable delay. If you are asked to describe this right, then you can say that it means that an accused person has the right to have their trial held in a timely manner. To add even more detail to your description, you can point out that whether a delay is reasonable or not depends on the circumstances of each case, including the number of witnesses that need to be interviewed and the time needed to analyse the evidence, which can be quite a while if it is necessary to conduct complicated forensic tests, for instance, as where the corpse of a murder victim has decayed considerably before it has been discovered. To give you a real-life example, in January 2017, a man, Jimmy Gargasoulis, deliberately drove his car down Bourke Street Mall in the city, killing 6 people and seriously injuring 27 more. Jimmy Gargasoulis was charged with murder in January 2017 and he was held on remand. That means he was held in jail until his trial. Given the number of people who were killed or seriously injured, given that the number of witnesses ran into the hundreds, and given the need to obtain medical reports about Jimmy Gargasoulis' mental condition and his drug addictions, it took the prosecution a considerable period of time to prepare for Jimmy Gargasoulis' murder trial. In fact, Jimmy Gargasoulis' trial was not held until June 2018, that is 18 months after he was first arrested and remanded to prison. In the circumstances, this could be considered a reasonable delay. However, 18 months would not be a reasonable delay in a much simpler case, such as if Jimmy Gargasoulis had robbed a milk bar where the only witness to the robbery was the milk bar owner. So what is reasonable or unreasonable depends on the circumstances of each case. Particularly to the extent a person is held on remand, that is, kept in prison until their trial, then the right to be brought to trial without unreasonable delay is consistent with the presumption of innocence. The presumption of innocence is that an accused person is presumed to be innocent until proven guilty. Where a person is being held on remand, they are still entitled to the presumption of innocence because they have not yet had their trial. Now, it is inconsistent with the presumption of innocence for a person to be kept in prison unless they have been found guilty, because that person is presumed to be innocent, and innocent people should not be kept in jail. The right to be tried without unreasonable delay is therefore consistent with the presumption of innocence because an accused person who is being held on remand is presumed to be innocent. And so, to the extent that such a person has to be kept in prison until their trial, it is important that that person is not kept in prison for an unreasonable period of time. That is, it is important that their trial is held without unreasonable delay. As this slide shows, there are currently significant backlogs in the Victorian criminal justice system which result in accused people suffering from lengthy delays in having their cases dealt with by the courts. According to a report by the Productivity Commission released in January 2023, these delays are occurring across the Victorian criminal court hierarchy. These delays are most serious in the Magistrates' Court, where, for example, around 30% of criminal cases, that is, over 25,000 criminal cases, have been waiting for more than 12 months to be dealt with. Part of this backlog is due to the cumulative delays caused by the COVID-19 lockdowns and restrictions, which reduced court operations during that period. And part of this backlog is due to the government not appointing enough magistrates to deal with the extensive workload of the Magistrates' Court, which hears over 83,000 cases every year. This brings us to the second right of an accused as set out in our learning intention, which is the right to silence. You need to be able to both identify the source of this right and to describe this right. The right to silence gives two main protections to an accused. The first protection is that an accused has the right to refuse to answer any questions asked by the police. This right is relevant before the accused's trial and arises when the police arrest an accused or interrogate an accused, that is, ask the accused questions in a police interview. In either of these circumstances, the accused can refuse to answer any questions that the police ask them. The exception is that an accused must give their name and address to the police. The source of this right is the common law, that is, the law made by the courts. However, this right is also supported by statute law. Under Section 89 of the Victorian Evidence Act, the fact that an accused has refused to answer questions asked by the police, for example, when the accused is being arrested or interrogated by the police, cannot be used at the trial of the accused to draw an unfavourable inference, that is, a negative conclusion. Put another way, and this is the way that I would like you to remember it, the fact that an accused has exercised their right to silence by refusing to answer questions asked by the police cannot be used as evidence at their trial that the accused is guilty. The second protection that is included in the right to silence is that an accused cannot be forced to give evidence at their trial. Where an accused exercises this right, not only does the accused avoid giving evidence in response to questions asked by their lawyer, that is the defence lawyer, in examination in chief and re-examination, but most importantly for the accused avoids being cross-examined by the prosecution. However, the accused can't pick and choose. If the accused decides to give evidence, then the accused can be cross-examined by the prosecution. The source of this right is the common law, that is the law made by the courts, and the Victorian Charter of Human Rights and Responsibilities. Under the Victorian Charter of Human Rights and Responsibilities, an accused must not be compelled to testify against themselves. That is, an accused cannot be forced to give evidence at their trial. This is just another way of saying that the accused has the right not to give evidence. That is, that an accused has the right to silence. This right is also supported by the Victorian Jury Directions Act. Under Section 41 of that Act, if an accused does not give evidence, then the trial judge should generally direct the jury that, first, the accused is not required to give evidence, and second, the fact that the accused did not give evidence is not evidence against the accused. Put another way, and this is the way that I would like you to remember it, where an accused exercises their right to silence by not giving evidence at their trial, the trial judge should direct the jury that the jury cannot use that as evidence that the accused is guilty. Like the right to be tried without unreasonable delay, the right to silence is consistent with the presumption of innocence. As I've already said, the presumption of innocence is that an accused person is presumed to be innocent until proven guilty. The right to silence is consistent with the presumption of innocence because a person who is presumed to be innocent should not have to provide either the police or the prosecution with evidence that could be used to prove that the accused is guilty. Instead, it is the responsibility of the police and the prosecution to independently obtain evidence that proves that the accused is guilty. This brings us to the third right of an accused as set out in our learning intention, that is, the right of an accused in a criminal case to a trial by jury. There are two sources of this right. The first source is Section 217 of the Victorian Criminal Procedure Act. This section gives an accused the right to be tried by a jury for a Victorian indictable offence. The second source of this right is Section 80 of the Australian Constitution. This section gives an accused the right to be tried by a jury for a Commonwealth indictable offence. When you are answering a question in a SAC or exam about the right to trial by jury, you need to decide whether the offence for which the accused is being tried is a Victorian indictable offence or a Commonwealth indictable offence. It's only by doing this that you'll be able to accurately identify the source of an accused's right to trial by jury. Most criminal offences are actually state offences. That is, they are offences which are created by state legislation. In Victoria, this includes offences such as murder, manslaughter, burglary, kidnapping, rape, theft, and so on, which are tried in the County Court or the Trial Division of the Supreme Court. If the offence is a Victorian indictable offence, then the source of the accused's right to trial by jury will be Section 217 of the Criminal Procedure Act and not Section 80 of the Australian Constitution. However, there are also Commonwealth indictable offences, that is, offences created by Commonwealth legislation. Examples include importing drugs into Australia, committing acts of terrorism, or not paying income tax. If the offence is a Commonwealth indictable offence, then the source of the accused's right to trial by jury will be Section 80 of the Australian Constitution and not Section 217 of the Criminal Procedure Act. The other point to note about the right to trial by jury, both for Victorian offences and Commonwealth offences, is that this right only applies where the trial is for an indictable offence. An indictable offence is a more serious criminal offence. An accused does not have the right to trial by jury for a summary offence, that is, for a more minor criminal offence. As I've said, in Victoria, indictable offences are heard in either the County Court or the Trial Division of the Supreme Court. On this slide, I've included some tips that you should remember about the rights of an accused. First, learn the source of each right as well as the content of each right. This is because you must refer to the source of these rights when answering questions about them. You don't need to remember the section numbers, although it would be impressive if you did. Second, when describing and giving a source for the right to silence, remember that this right actually consists of two protections. The first protection is the right to refuse to answer any questions asked by the police, except that the accused must give their name and address. This is relevant before the accused's trial, in particular where the police question an accused while arresting them or interrogating them in a police interview. The second protection is that an accused cannot be forced to give evidence at their trial. Third, don't confuse the right to trial by jury for Victorian indictable offences under the Criminal Procedure Act of Victoria with the right to trial by jury for Commonwealth indictable offences under the Australian Constitution. And finally, read any SAC or exam question carefully to see whether it is asking you about the rights of the accused or the rights of the victim. We'll be dealing with the rights of victims in the next video. Well, that brings us to the end of this video on the rights of an accused. As a result of watching and taking notes on this video, you should now be able to explain the rights of an accused, including first, the accused's right to be tried without unreasonable delay, second, the accused's right to silence, and third, the accused's right to trial by jury. Remember, you need now to read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.